MSEduventure, a venture for a social cause.
Hello, my name is Advocate Madhusudan Shetty and welcome to the sixth episode of MSEduventure. Our topic for today is the topic which we left in the previous episode, that is arrest and bail, and today we are going to talk about the bail provisions of CRPC. Bail can be granted as a matter of right in bailable offences. Now, bailable offences are those offences which are of less serious nature. However, in non-bailable offences, bail cannot be claimed as a matter of right, which also does not mean that in non-bailable offences one cannot seek any bail at all. Bail is granted only at the discretion of the judge. Talking about the discretion of the judge, Benjamin Cardozo, in his book called as The Nature of Judicial Process, has stated about discretion of a judge that the judge, even when he is free, he is still not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his own ideal of beauty or of goodness. He is to draw inspiration from concerted principles. He is not too ill to spasmodic sentiments, to vague and unregulated benevolence. He is to exercise his discretion informed by tradition, methodized by analogy, disciplined by system, and subordinated to the primordial necessity of order in all the social life. Wide enough in all consigns in the field of discretion that remains. To sum it up, the judge has to use his discretion in the best possible way, bringing justice as well as balancing the right to liberty of that person who is accused. Now, we need to also remember that in Babu Singh versus State of Uttar Pradesh, it has been very explicitly mentioned that when the accused can show that he has got some link to his community and there is no possibility of him to abscond, bail can always be granted. This is what has been the ruling of the Supreme Court. So, talking about bail, we are going to discuss bail in 3 to 4 provisions. Okay, so let's see what we have to start with. On the screen, you see one person assaulting another. Now, this calls in for a punishment under section 352 of IPC for assault or use of criminal force except under great provocation. The punishment for this offence is a imprisonment term for a period of 3 months or fine of rupees 500 or with both. This offence is triable by a magistrate and it is a bailable offence. So whenever there's a bailable offence, the provisions of section 436 of CRPC comes into play. As I said earlier, in bailable offence, bail can be claimed as a matter of right. So whenever a police officer is arresting a person accused of a bailable offence, or if this person is brought in front of the judge and if he's prepared to give bail, this person should be released immediately on bail. Now, bail very simply means giving an assurance in the form of money or personal bond, giving an assurance of his presence whenever he's been called in front of the court or in front of the police station for investigation, and in any way he is not going to be detrimental to the process of investigation of the case. Now, there are some specific provisions of section 436 which we should know. If a person is indigent, because generally very poor people get trapped into these offences, if the person is indigent, that means is poor and is unable to furnish surety, he can be released by the police officer or by the court on furnishing of a personal bond. Personal bond means he is giving his own assurance, and this bond will contain his address, his source of income, his place of employment, etc., etc. And this bond specifically talks about giving an assurance of his presence whenever he is called in front of the police officer or in front of the court. Now, one more provision that talks about that we need to understand in section 436 is that even after a week's timeline has been passed by and the person is not able to furnish any surety in a bailable offence, now these are sufficient grounds for the police officer or the court to believe that this person is indigent and is unable to furnish surety, which means this person should be immediately released on bail on a personal bond. Suppose a person commits a non-bailable offense. Bail cannot be claimed as a matter of right under Section 436 of CRPC. So here, Section 437 of CRPC comes into play, wherein it states that any person who is accused of a non-bailable offense may be granted bail. The word may be implies it's as per the discretion of the magistrate. However, in Lombard-Corgan versus State, it has been stated that in all non-bailable cases except cases relating to offences punishable with death or imprisonment for life, judicial discretion would always be exercised by the court in favor of granting bail unless exceptional circumstances were brought to the notice of the court which might defeat proper investigation and fair trial. So the criminal jurisprudence is always in favor of granting a bail. In series of judgments, the Supreme Court along with other courts of this country have stated that bail needs to be granted. Noteworthy among them is Emperor versus Hutchinson, wherein the Justice Mukherjee said that grant of bail is the rule and refusal is the exception. It goes without saying that an accused person, if he enjoys freedom, will be in a much better position to look after his case and to properly defend himself than if he was in custody. The criminal jurisprudence follows the simple rule that every person is presumed to be innocent unless proved guilty. Now, Section 437 provides special cases wherein a bail can be rejected. A bail can be rejected if it appears reasonably that the person is guilty of offense punishable with death or imprisonment for life, like rape or murder. The person may not be granted bail immediately or very easily. Also, a person shall not be released in bail if it appears that he has been previously convicted with an offense punishable with death, imprisonment for life, or imprisonment for 7 years or more. Also, a bail can be rejected or not released on bail if it is very clear that the person has been previously convicted on 2 or more occasions of a cognizable offense with imprisonment for 3 years or more but less than 7 years. At the same time, Section 437 of CRPC has some concessions for special group. It states that in its provision that any person who is under the age of 16 or is a woman or is sick or an infirm, that person can be released on bail. Okay. However, there are specific crimes forein the bail can be granted but with specific conditions. For example, the cases wherein we have offenses against the state, offenses against human body, offenses against property, or its abatement or conspiracy or attempt to commit any such offense, bail can be granted to such individuals, imposing extra conditions to secure the presence of the person on trial and to ensure that such person shall not commit a similar offense. So these are the provisions of Section 437 of CRPC. The court also has the discretion of granting interim bail and also temporary bail to the accused for health reasons. But one thing that we should know is something called as compulsory bail, which has been enumerated under Section 167 subclause 2. Now, the clause very clearly says that whenever a person is in custody and the investigation is not completed, that means the charge sheet is not filed before the court for a period of 90 days when the investigation relates to the offense punishable with death or imprisonment for life or an imprisonment for 10 years or more, and in all other offenses for a period of 60 days if the charge sheet is not been filed. At the end of this 90 days or 60 days respectively, the accused can claim bail as his right. When I say the bail can be claimed as his right, it is compulsory for the court to grant a bail. Hence, this is called as the default bail or order on default. Besides this, following the Husainara Khatun versus State of Bihar case, Section 436A was introduced in the Criminal Amendment Act, wherein it says when a person who is an under trial, that means the trial has not been completed, and this person has been under detention for a period which is one half of the maximum punishment prescribed for this offense, this person is entitled, he shall be released on bail on granting his personal surety, personal bond with or without surety. The only exception is that the person should not have committed or accused to have committed an offense for which death is one of the punishments. A form of pre-arrest bail is anticipatory bail. Section 438 of CRPC lays down the provision for anticipatory bail, wherein it says that any person who has reason to believe that he may be arrested on accusation of having committed a non-bailable offense, he may apply to the High Court or the Court of Session seeking direction to grant him bail when such an arrest does happen. The word reason to believe is very broad, and having filed an FIR is not the prerequisite of going and applying in front of the High Court or the Court of Session seeking an anticipatory bail. However, before granting an anticipatory bail, the court will look into the following consideration, that is, the nature and gravity of the accusations, how severe it is, the antecedent of the applicant, whether he has undergone imprisonment for a punishment prior to this or not, possibility of an applicant to flee from justice, or the accusation made, is it just merely to injure or cause humiliation to the applicant by having so arrested. Having considered these matters, the court will definitely grant an anticipatory bail to this person. Section 439 of CRPC grants inherent power to the High Court as well as to the Court of Session, giving them a concurrent jurisdiction in granting bail at different stages. The general conditions also includes the cancellation of bail, wherein the magistrate or the judge can cancel bail in the change of circumstances and as per need. A bail can always be applied. There is no limitation period for application of a bail. So once a bail is rejected, it does not mean the person cannot apply for a bail again, provided there has to be a change in circumstances. Okay, if there is no change in circumstances and if a bail is rejected by a court, it can be further appealed to the higher court for granting of bail. In this way, a bail can basically seek every time whenever there's a rejection of bail. Besides this, Section 389, Section 397 and Section 401 of CRPC deals with provisions related to bail at an appeal and revision stage for an accused. So, to sum it up, bail is a very important provision that is necessary for seeing that proper justice is done to the accused and to the victims also. Thank you.